My name is Lara Kroll, and I'm the Senior Health Human Resource Analyst for the BC Care Providers Association. And I'd like to welcome you to today's webinar, which is focused on the new paid sick leave standard under the Employment Standards Act, and how that will impact the seniors living and continuing care sector. Before we get started, I would like to acknowledge that we're gathered on the ancestral and unceded territory of the First Nations, Inuit, and Métis peoples across British Columbia. We thank them for being good caretakers of this land and allowing us to be visitors on this shared territory, and for the ability to host this dialogue here today. A few housekeeping items before we get started. We're going to be using Zoom webinar today, which means that if you want to ask a question, we do ask that you pop it into the Q&A function. I can direct those questions to Danny at the end, or he's also given us the opportunity to ask questions throughout. So that is how that process will work. Please do note that the session today is being recorded, and that recording will be available to all delegates after the session. We're also going to be making the slide deck available, so don't feel that you have to take screenshots of the slides or anything. We'll be sending that to you as well. On that note, I'm pleased to introduce Danny Bernstein. Danny is a partner at Roper Greyell, where he provides strategic and timely advice to clients on labor, employment, and human rights issues that arise in the workplace. He advises employers throughout Canada through a wide range of industries, including healthcare, which is why we've invited him here today for this wonderful dialogue. Without further ado, I'll turn it over to you, Danny, for the presentation.
Yeah, thanks very much, Lara. I'll just point out as well, given my setup here, I won't be able to see necessarily questions coming in, so we can resume review at the end, or if you want to interrupt me throughout with questions, that's fine as well.
Yes, I'll interrupt if I see something timely coming in.
Excellent. That'll be great. I appreciate that. So thanks, everyone. I saw the attendee list before this afternoon, and I think there are some folks on the webinar who I've worked with before. So nice to connect with you again. And for others who I've not worked with before, thanks for joining. Thanks to Lara and the BC Care Providers Association for giving me the opportunity to present. It's obviously a very topical and timely discussion. It was very interesting for me to do a bit of a deep dive into this and think about how it's going to impact this sector and different industries. So I'm looking forward to it. So without further ado, then let's get underway. I've got my slide deck up here. As you can see, the introduction here, we're talking about some new sick leave provisions. Two pieces to that are the COVID paid sick leave that's been introduced as of May of this year and is currently in place. We'll talk on that briefly, but we'll really focus on what's coming into effect in January 1 of 2022, which will be a number of paid sick days, general sick days, not specific to COVID. We just don't know how many yet, and we'll talk about that as well. So all of this is coming about because of what's called Bill 13. So you may hear people just simply talk about Bill 13, and that is an amendment that is being rolled out to BC's Employment Standards Act. As everyone will know, it's the Employment Standards Act that sets out all of our minimum terms and conditions of employment for both unionized and non-unionized employees, basically everyone except for exempt employees in British Columbia. So what is Bill 13? Very, very high-level overview here. There are two parts to it. It essentially is a government response to what was a lot of public demand, particularly as the pandemic got underway and people realized that they may actually be forced to take time off work and would not be having paid sick leave for it. So there was the introduction of an interim measure, which was paid sick leave for COVID-related leave, as well as there was the introduction of unpaid COVID-related leaves, and we'll talk about that briefly. But then starting on January 2022, as I mentioned, there's going to be new paid sick leave. Currently, the government has a consultation process underway. You may have seen or participated or been encouraged to participate in some online feedback. I have some statistics here that I'll share as part of that. The government is currently trying to decide how many days, either 3 or 5 or 10, will be general paid sick days going into the next year. So, more specifically, what has happened? What is Bill 13 actually doing? So firstly, what we have is a new section of Employment Standards Act that created an entitlement to paid leave for COVID-related circumstance. And this is very prescriptive. So to meet the criteria for these paid days, 3 paid days, an employee has to either have been diagnosed with COVID-19, had to be told to be in quarantine or self-isolation, or directed by an employer to not work because of concerns for an exposure. There are also unpaid COVID leave entitlements. I haven't got them up on the screen, but they're broader than what we have. So I think an easier way to look at it is there's 3 paid sick days for these prescribed circumstances. If an employee exhausts their 3 paid sick days, they still get unpaid leave for these same circumstances, but they can also get unpaid leave if they're providing care to an eligible person, a family member, for example, or they can't return to BC due to travel restrictions, which I think would be fairly limited. That was sort of more early on, or if a prescribed situation exists. We don't need to get into all of the details on what a prescribed situation might be. So we've created this chart, which I hope is helpful here. So all 6 reasons here on the bullets entitle someone to COVID leave. It's only paid if it's a COVID diagnosis, they're in quarantine or self-isolating, or have been directed to be absent from work. For example, because there's an outbreak, or there's a colleague has been exposed and there's concerns of exposure for that individual. I see there's a few comments in the chat. Lara, anything we need to address yet, or should I carry on?
No, sorry, those were mostly just me giving the participants instructions about the Q&A function. So thanks for checking in, though.
So let's keep talking briefly then on the COVID-related leaves. As I've said, there's 3 days, and it is up to 3 days, which means an individual could take 3 days at once, or they could take a series of 1 day and 1 day and 1 day, so long as on each occasion they qualify with one of the criteria. Situations that I've discussed with clients are where an employee has, for example, exhausted their 3 days at some point in time since May, and then another circumstance arises. But once those 3 days are used, then there are no more paid days, even if it is another circumstance that would generate paid sick leave for COVID reasons. Then they would qualify for the unpaid COVID sick leave, but it wouldn't be paid twice. Employees obviously have to request that and specify that those are the reasons. And certainly as an employer, you are entitled to ask some questions as to why someone thinks it is a COVID-related leave as opposed to an ordinary leave, an ordinary sick leave, for which you may have other criteria in your collective agreement, or they may just be entitled to the regular time off unpaid. And then there's also conditions around returning to work, which we don't need to get into, just to be aware that there are set conditions for employees before they can return on a COVID-related leave. It's not contingent on vaccination status. This was introduced before the whole vaccination piece came and became part of the discussion. Interestingly, I'll talk about this now. Bill 13 doesn't address the reimbursement program, and I'm sure a lot of you have heard or perhaps even participated in the reimbursement program, which is being run through WorkSafe BC. I don't intend to dive into those details specifically, but just to be very clear that it relates to these 3 paid COVID sick days. It isn't right now going to relate to the 3 paid regular sick days that are going to be introduced next year, and we don't anticipate there to be a reimbursement for those new sick days coming into place. So if you are an employer and you don't have any paid sick days right now, or you don't have 3, you may be eligible through WorkSafe BC for reimbursement of having to pay for those COVID-related sick days. But I think the expectation, and Bill 13 certainly doesn't address reimbursement for paid sick leave going forward. So I don't think we're going to see that.
Danny, if I can interject, we had a timely question come in through the chat. Chris asked, so the 3 paid COVID-related sick days are over and above the sick leave entitlement that the employer already offers?
No, not necessarily. I think if an employer already offers 3 paid sick days, then you are already meeting that statutory requirement. This is to ensure that those who don't have any paid sick leave are going to get at least 3 paid sick leave days.
Right. I think that clarification is really helpful.
Yes, good question.
The second question that came in, and again, it's a really good one for Margot. Can an employee get the 3 paid sick days from more than one employer?
Yeah, I haven't thought about that. I don't see why not. As long as it's, I mean, it would be up to each employer to provide it separately. So my guess is yes, that they can. And I think the situation you're probably getting at is someone works for 2 different employers at the same time, and then they're sick with the same reasons at the same time. Do they get sick leave from both? Probably, because they're probably not working full shifts for both employers at the same time and not overlapping each other. So it would more be about how much, what the value of the sick pay is prorated to what they work. So that I don't know exactly, but that's my guess.
Okay, great. Thank you. Interesting question. Thanks, Margot.
Yeah. Okay, should I carry on?
Yes, please.
Okay, so this COVID-related leave is going to be repealed. So once we're into the new year, we're not going to be talking about COVID leave anymore. We're just going to be talking about regular sick leave. And that is where we find ourselves here. Let me just get to it on my notes. So I mentioned that there has been some a consultation period going on with the government. They've been asking individuals and employers to comment and provide feedback. It's been in place for quite some time now. I'm just going to go through some of the statistics because they are interesting to see. I think what's driving this from the individual perspective, the employee, as well as from the employer perspective. And apologize if you've already read through this, but I'll just share some highlights. So the survey results have found that approximately 1/2, so 50% of employees do not have employer paid sick days, and that it's more likely that they don't have employer paid sick days in lower paid jobs. So disproportionately impacting those, I think, in lower paid jobs. And from those that have employer paid sick days, more than 80% have at least 3 per year, 3 paid sick days per year, and close to a third have more than 10. So I think that probably is skewed with the unionized environment. I think there's probably not a lot of non-union environments that have more than 10 paid sick days. But once there are paid sick days, it seems to be 3 is almost the minimum. And then with probably a few outliers, and then 10 seems to be the upper end of the range. Interestingly, this is one thing that I've always struggled with when we talk about sick leave policies, and I've heard from my clients, is if you provide more sick leave, people are just going to use it. And maybe they're not sick, or maybe they're not, maybe they don't need it, but they see that they have it and they're going to use it anyway. So of the survey results, for what we can rely on it for, 70% of employees said They typically don't use all of the paid sick days they get each year. So 70% not using all each year. But those who don't have sick pay reported that they regularly go to work sick. And I think one of the underlying policy reasons for this change and what we've really learned through COVID is that we don't want employees attending at work when they're unwell. I think it used to be a bit of a badge of honor to drag yourself out of bed when your head's full of a cold and off you go to work and you're coughing and spluttering and everyone around you sort of keeping their distance, but no one really said you shouldn't be here necessarily. I think that is one of the real things this is trying to address. And certainly when most people are saying they regularly go to work when they're sick, I think that sort of drives home that point. In terms of employers, so of the employers that offer sick leave, 45% are 3 to 5 days, 25% 6 to 10, 20% more than 10, and almost 10% are less than 3 days. So I think we can see there's a whole range of employers, and we're going to talk about the impact of these introductions. But it does seem to me that there's going to be the majority of workplaces are already providing paid sick leave of some sort. So there will be a few workplaces that have none, and they will be impacted by having to create a new paid sick day pool. But not, it won't, I think the majority of workplaces will already have something in place. Okay, so that's the survey. I'll move on from that. This slide we have here, just talking about what's actually happening. So currently, you can see here the current entitlement. We have already unpaid sick leave of 3 days for personal illness or injury. What's going to happen is there's going to be paid sick days for a number of days prescribed for personal illness or injury. So that's going to be on top of the unpaid. So we're keeping 3 unpaid. We're adding a certain number of paid sick leave days, and it could be 3 days or 5 days or 10. Those are the numbers being looked at the moment. There's still the same requirement that the entitlement arises after 90 days of employment. So you have to qualify by doing 90 days. The point here I just wanted to make is the Employment Standards Act doesn't distinguish between casual or full-time or part-time employees. An employee is someone who provides labor for an employer. So the way that the different categories of employees might be impacted differently is how they calculate sick pay. And there's a formula set out in the amendments that talks about looking at the past 30 days and taking an average day's wages. I think it includes vacation pay paid over that time, but not overtime, and then figuring out what a day is. So someone who's casual and who only works perhaps once or twice in that 30-day period, their day's pay might be calculated differently from someone who's full-time, who's been getting, obviously getting paid more regularly during that time. The point that I've got here, reasonably sufficient proof. This is an interesting one. So this standard already exists right now in the Employment Standards Act for sick leave. And then it existed before the COVID leaves were introduced. And with COVID leaves, the government, the legislation said that you're not allowed to ask for doctor's notes. And if everyone casts their mind back to March, April, May 2020, where doctors' offices closed down and everyone was at home and everyone was doing everything possible to not send people to the doctor's offices. And I remember this discussion many, many times and sort of clearly etched in my brain that we didn't want to force employees to go to a doctor to say, I have COVID symptoms, to get a note to absent themselves. And so that was when the paid COVID leave, all the COVID leave provisions were introduced. The government said, well, you're not going to be able to ask for a doctor's note. So you can still ask for reasonably sufficient proof, but there was a separate exemption that said not a doctor's note. Now, we don't see that same provision, that same caveat with these new sick leave provisions. So we do think that you're going to be able to rely on just the same rules as it was pre-COVID, which is you will be able to get a doctor's note if someone is trying to access paid sick leave, just as you would previously. If reasonably sufficient proof is the standard, we think that will include the ability to ask for a doctor's note. And that's, I've got a little ahead, that's what this slide is talking about here. So you don't have to get a doctor's note. There's no obligation to do it. It will depend on what your own policies already say, but contemplate what you are going to require for proof of someone's accessing this sick leave. Again, remembering that it's for personal illness or injury that this paid sick leave is coming about. Any questions, or should I carry on?
I'm not seeing any questions in the chat at the moment. Just a reminder that you can pop them in, but I will interrupt if I see something interesting.
Okay, I will carry on. So this is the biggest part of these new sick leave provisions is the meet or exceed principle. I'm sure you've heard of it before. Our Employment Standards Act has had this requirement previously. There's been various legislative changes over the past decades to go. We're now back where we were like in the 80s, in the 90s it changed. Most recently, we actually, the Employment Standards Act removed this meet or exceed concept, so to speak, and said that if your collective agreement deals with certain issues like wages, overtime, hours of pay, hours of work, etc., you didn't have to compare it to the Employment Standards Act. That was repealed by the NDP, reintroduced the meet or exceed provision. And now what we have, why we're talking about this, is because now we need to look at it specifically in relation to these new sick pay provisions, specific to COVID sick pay and specific to the new general sick pay, which is coming in. So as a general principle, you can think that what you're looking at is whether this, I should also say, sorry, this is only for unionized employees, but I understand at least the majority of folks on this webinar will be either entirely unionized or mostly unionized. So you need to assess, if you have a collective agreement, do the provisions of that collective agreement meet or exceed the entitlements provided under the Employment Standards Act? If they do not, then the Employment Standards Act provisions are inserted by statute into your collective agreement. So that's the point, the first bullet point here, if your collective agreement provides less than the statutory minimums, then the ESA is incorporated in. If the collective agreement exceeds, then the collective agreement prevails. And as I said, this is specific to the COVID-related leave. So if currently right now, if you don't have paid leave provisions for COVID-related reasons, then you are not meeting or exceeding employment standards and you will need to provide that. I expect that if you've not had an issue about this so far, then you're probably okay. Or you've already discovered that you were not meeting and exceeding and have made revisions probably through discussions with your union, or you were already meeting or exceeding, in which case you've just carried on. So really the bigger question is, will you meet or exceed Employment Standards Act provisions going forward once this new paid sick leave is introduced? So how is this happening? Why is this happening? This is more of just the legal side of things. What's being introduced are two new provisions, and you can see them here. We don't need to read them all, but effectively, this is for the COVID leave, you can see here, and there's a new provision that says if the collective agreement language meets or exceeds the minimum requirement of the Employment Standards Act, then the provisions of the collective agreement replace the requirements of the Act. But if you do not meet or exceed in your collective agreement, then the Act is deemed to be incorporated into your collective agreement. That's COVID leave. It's exactly the same language, just in a different section for the general sick leave provisions. So really the question then is, what does it mean to meet or exceed? I'd be interested if anyone has actually gone through a challenge. Maybe you can comment about it in the chat or ask a question, but it comes up in a variety of settings. As I said, it's been the law for decades now, and we've looked at it in overtime or vacation pay or sick leave or hours of work. It's not a new concept. What it means is specific to the circumstances of the collective agreement, so that there is no one-size-fits-all analysis. There's no scientific test or mathematic formula. You have to look at the context of the specific collective agreement. So right now, if you're going to meet or exceed, you're going to need to have at least 3 paid leave days that relate to COVID circumstances. And after January, either 3, 5, or 10, and we'll find out hopefully shortly what that number is going to be. The test, the way it's developed, goes back to some decisions that I'll review with you. But more generally speaking, you can say that the contractual provisions, so your collective agreement, and this is the really key part, it has to be looked at as a package. Is it at least equal to the relevant statutory provisions viewed as a package? So what that means, and the language that the case law uses is the provisions that we're looking at, do they have a rational and meaningful connection to the subject matter of the statute? So when we look at sick leave, we don't just say, okay, the Employment Standards Act says 3 days sick leave. Your collective agreement says 2 days or 0 days or whatever it might be. Therefore, you're not meeting and exceeding. You have to look at the whole package. Where this is going to be important is going to be when you're looking at different categories of employees, because you may have some employees who have entitlements, like full-time regulars, for example, that substantially exceed the 3 days. But if we're at 10 days, then it may be a different analysis. Maybe you don't have the majority of your employees who substantially exceed that. You may have auxiliary employees or casual employees who don't get paid sick days. But fortunately, the case law and the way it's developed has said you still are entitled to view the collective agreement as a package. You don't pull out individual circumstances and say, well, this particular employee, how does it apply to him or her? And is it meeting or exceeding for them specifically? You're entitled to look at it more broadly than that. And that's this point here where we say provisions cannot be cherry-picked, meaning that a union, for example, or an individual can't take their individual circumstances and say, well, for me personally, I'm better off with the 3 paid statutory sick days, so I'm going to take those. And I'm also going to keep these additional collective agreement provisions that I get to. You have to look at everything as a package. So what I might do, if I can, is there's a slide here. What does this all mean? So going through some more specific examples, but I'm just going to mention some of the leading cases here because it is what gives us the foundation for knowing what we're going to be looking at. Luckily, we've got case law on very similar language in the past. So one of the first and major case is called Crestbrook Forest Industries. And I'm happy, Lara, to provide citations if people want them. They're not going to be in these slides, but if people do want, I'm more than happy they can contact you or me to get them. So in this case, Arbitrator Munro looks at the meet or exceed test in the Employment Standards Act. It's a 1994 case and says, first, what we need to do is look at the sections of the Act that have a rational and meaningful connection with the subject matter that we're looking at. Then you identify and consider the provisions of the collective agreement that have a rational and meaningful connection to the subject matter. And then you look at the contractual provisions as a package. Are they at least equal to the statutory provisions as a package? So you can't pull out a specific concept in isolation, or a specific provision, sorry, in isolation. You have to look at it as a package. So specifically, when we're looking at sick leave, there's going to be the broader benefits package. There might be regular paid time off. There might be sick leave. There might be short-term disability, short-term wage loss indemnity. There might be other days, personal days, float days, birthdays that you'll need to look at as a package. Look at the circumstances that an individual can access those days, and then decide, okay, when we look at this, am I meeting or exceeding the paid statutory sick days? And I think where that will become really important is if we see 5 or 10 paid sick days, because I'm anticipating for the most part, if there's 3 paid sick days that are introduced, most collective agreements will exceed that, and there won't. You'll be able to do a direct comparison because you'll have that amount of sick pay. But if, for example, you've got a situation where we get introduced 10 paid sick days, and you only have 8 paid sick days, but one can also bank those to a total of 15 paid sick days. Or you can use 8 paid sick days, but then there's also additional statutory holidays, or there's additional personal days, overtime banking days. There's other ways that you would have to look at your overall package to decide whether you are meeting or exceeding the sick leave provisions. There's another case more recently that you may be aware of or have heard of. This is Community Social Services Employers Association. So again, right on point for this industry. It was decided with different language. This was the Employment Standards Act had been somewhat amended, but we still had the meet or exceed provision. And this is where the board says you can't just take an individual and look at how it would affect them, and then decide whether the provisions meet or exceed. You have to look at the majority and the overall employee pool, and look at whether the collective agreement, when applied to the group, meets or exceeds the minimum standards, because there will always be individuals who are dipping below the statutory standard, and there will be groups who are way above, and it's the bigger picture that you need to take into consideration. So what we get from that is that it is still possible in a unionized environment for a collective agreement in some aspects to go below the statutory minimum. For example, if we're looking, I think, at casuals or auxiliaries who don't get sick pay, if they are the minority, and when you look at it for the majority of employees, they are meeting or exceeding, as in the collective agreement as a package, as a whole, in that workplace meets or exceeds. There's going to be some individuals who maybe aren't meeting or exceeding, or aren't getting that minimum requirement. You can't impose sick pay for them and only them, and have now sort of different standards or tiers that apply to them. So you're not going to be required to have different sets of rules for different employees within your collective agreement. Looks like there's a few chat comments there.
Yes, so we did have a question that I was able to address. Chris was asking about the formula for paid sick time for casual and part-time employers. So I was able to pop the government website in the chat where she can take a look at that formula. If you don't mind, I think I just want to drill down on that meter exceeds piece for casuals. That was one of my questions going into this webinar, and I really appreciate the clarification that when it comes to a unionized workplace, that you're looking at it holistically. I know that that was one of the key pieces that some of our employers were concerned about when it comes to the meets or exceeds clause. The piece that I'd like to drill into a little bit, because we do have a number of employers on this webinar who have non-unionized workplaces as well, is, can they how does it look under the new Employment Standards Act if they are, for example, paying a casual worker a percentage of their straight times earnings in lieu?
Yeah. I'm glad you mentioned that. I had intended to get to it, but now I'm glad you mentioned that because it is a really good point. I think for a non-union employee casual, if you're grossing up their wage or salary, I guess it would be wage or their hourly rate by some amount in lieu of benefits, for example, which happens quite often, I think it's going to be a hard sell for an employer to say that is meeting or exceeding 3, 5, 10 paid sick days. I do think that you're going to need to look at whether you perhaps reduce that benefit, the gross up, by an amount and add paid sick days, or at least look specifically at what it is that benefit already covers, that gross up already covers, because it likely doesn't cover paid sick time. And I don't know that you could shoehorn it in necessarily. I also think you're going to have a hard time saying, well, an extra 8% or 6% or whatever it is equal to 3 paid sick days. And I don't know what the math works out to be. But I do think for those casuals who are, or non-union employees, I guess any of them who aren't paid sick time, but who get something in lieu of that, that is probably one of the areas that is going to be most challenging.
Okay, I really appreciate that clarification. Sounds like this is going to be a really crunchy area for those employers that are not unionized. I have 2 questions that have come in, so I'm going to handle the easiest one first. Chris is just wanting to clarify something you said earlier, Danny. She asked, if casuals currently are excluded from paid sick time in the collective agreement, but part-time and full-time staff are included, the operator is considered compliant with the new regs. And I believe that's in a unionized environment. More
than likely, because when you look at the collective agreement as a whole, as it applies to all of the employees, not just the casuals, as long as you're meeting or exceeding the 3 paid, 5, 10 paid sick days, then yes, that's what the case law says so far, is that you can dip below it in certain aspects, and you're not going to be expected to create a separate standard for different groups of employees or different individuals.
Great. I think that's really helpful.
Yeah. And I just will make one more point on that previous piece, which occurred to me as well. When we're in a non-unionized context, obviously we have concerns around constructive dismissal and making changes to people's terms and conditions. I would encourage employers to look at the ability to shift one pot to another pot. If you follow, like if you've got money allocated or resources allocated here, can you move them to this new area to create this paid sick leave rather than coming up with a new pot for the paid sick leave? It may be that you can do that without risking a constructive dismissal because it's a minimal impact here and it brings you up here. I don't think you necessarily have to just immediately create new paid sick leave if you're able to find a way within your existing benefit package to do that. And that's going to be a very individual assessment at the time.
Another question that is coming here is from, it's an organization that provides home support, and I believe it's a non-unionized environment. They say most employees in our business are casual. If they call in sick, we often don't have a replacement for them to cover a client visit. This means we can't actually charge the client. Do we still have to pay the employee? I'm assuming they mean, do they have to pay them the sick leave?
Yeah, without looking into it too much, I think you will. Yeah, I think that whether you have a replacement or whether you get paid for that time is not going to factor in. I think just picture outside of healthcare, picture workers on a factory floor. Someone doesn't come in for their shift. That means they don't make the number of phone calls they would have made or the number of widgets they would have made. So the company doesn't get the benefit of that labor, but they're still going to have to pay for that sick leave. So I think in that circumstance, you would still have to pay for sick leave. As long as they're scheduled for a shift that they don't come in. Obviously, if they're just at home and they get sick, but they're not scheduled, then they're not getting sick pay.
Okay, great. That's all the questions for now. So
Right.
continue on.
We'll continue on. Yeah, so let's go on. I think we've covered with these questions, which are really great. We've covered a lot of this already. So this is just to emphasize that for non-union employees, the meet or exceed doesn't apply, but obviously they still need to get the minimum statutory entitlement. At this point here, waiver of leaves is impermissible. Just be careful that you're not somehow having someone in a contract or a policy inadvertently waive their right to this paid sick leave, and that might come up in a policy around sick leave or time off work. So you'll have to look at that again to just make sure people aren't purporting to give up on their paid sick leave. And also here, careful with classifying people as independent contractors. If you do that and you get it wrong, well, then this is just another area, another liability that you're potentially accruing. If someone's an independent contractor, they're not an employee, so they don't get the protections of the Employment Standards Act. So you don't owe someone who's a contractor any sick leave, just like you don't pay the vacation pay or benefits or anything else. But if you get it wrong, this is just another spot where you've potentially accrued a liability to them that they could go to employment standards with, for example. Bit of a summary here. For non-union employees right now, it's only 3 paid sick days for COVID leave. But as of January 2022, you're going to be looking at 3, 5, or 10 days of sick leave. I've covered off here what I've called grey areas. This is where, well, this is where you call your lawyer and say, we're not quite sure. There's going to be, particularly in a unionized environment, when I talked about looking at the whole package, there's a lot of circumstances where it won't be a direct comparison. You will, and sometimes have just paid sick leave. And if we get 3 days of paid sick leave, I think most unionized environments will already cover 3 days of paid sick leave. We've talked about the casual piece, so you're probably okay. It's when, if we get 10, then you're going to perhaps have to start looking at what else do we have? Do we have discretionary paid leave? Do we have a number of different leaves that are not in the Employment Standards Act, that when we look at them as a whole, we're still meeting or exceeding? I think it's going to be a really interesting question how adjudicators would look at short-term disability benefits that have a waiting period. So we know a lot of packages have a 2-week waiting period before STD can kick in. And so how does that compare? If you think, well, I'm sick now, under the Employment Standards Act, I would be getting 3 paid sick days now. And an employer is saying, well, with us, you're going to get how many, 17 weeks or 14 weeks of paid sick leave, but you do need to qualify by waiting for this 2 weeks. And going back to my point about the policy reasons underlying this being that people shouldn't attend at work if they're sick, I do think there's going to be a hard sell to say that your waiting period still meets or exceeds. So you may end up then having to provide the paid sick days up front, as well as someone potentially qualifying for that sick leave. So that's going to be a really difficult area. Similarly, if you've got a generous sick leave policy, but it's unpaid, or it's part paid and part unpaid, I think as well, lots of collective agreements might protect job security for a long period of time, much longer than employment standards. But if it's unpaid, then again, is it a greater, does it meet or exceed? This is going to be where it is really difficult, hard to put hard and fast rules on it. It's going to be very much a case-by-case analysis. But I can see if there's going to be policy grievances and litigation on this, it's in these grey areas that it's going to mostly be.
Yeah, if I can jump in, I think that that was one of the questions I was going to ask. So I'm glad that you've come to it. And one of the tricky scenarios that was put to me by an employer, and I've seen this in a few different collective agreements, is some of them will have a short-term illness plan, for example, that will pay out for a period of 10 weeks, for example, but it pays out at 70% of straight time earnings, for example. It doesn't pay out at 100%. And I'm wondering, looking at that, how do you judge that and say, yes, that meets or exceeds 10 days of paid sick leave at 100% pay?
Yeah, that's really a good example. I mean, I guess one way is just a pure mathematics formula, right? What is one going to get paid? You'd have to think, for example, at 10 weeks over that period of time, you've got a good argument that that's meeting or exceeding. But then again, if it's a short-term illness, if someone's saying, look, I could get 5 days, for example, at 100%, and I'm not going to need more than 5 days because I just have a cold or a migraine and I'm not coming to work for only a few days, is that 30% gap enough that they don't meet or exceed? I don't have an answer for that directly. I think if it's a long period, I would strongly argue that it is meeting or exceeding because it's well and truly above. The closer you get to just meeting it, but for example, if you had 10 paid sick days at 70% and the rule was 10 paid sick days, I think that would get introduced over the top. You wouldn't be meeting or exceeding. If it was 5 and you had 10, maybe. That's a tough one, Lara.
I love to put tough questions, but I think what I'm hearing is that the employer should be A, consulting their lawyer, but B, thinking about the intent of this new policy, which is to make sure that people aren't going into work sick, but also doing a bit of a mathematical calculation. Yeah,
and seeing if they can shore up some areas. Maybe, for example, maybe you've got paid time off that isn't already intended for sick leave, but maybe you can change your policy so that people can access existing leaves, but for sick leave, so you can change the scope, or maybe you just need to make it more clear on what they can access and how they can access it.
I have a question that's come in here from Ashley, and I might ask her to clarify it, but the question is, if a casual worker was to pick up a shift, and then if they can't take it due to COVID, would they be eligible for the sick day? So maybe it might be helpful to clarify whether we're talking about the COVID leave or the permanent paid sick leave.
Yeah, I mean, I think the answer is yes in both circumstances. I think now they would get the COVID sick leave, and as of January 1, they would just get a regular sick leave day. It doesn't, next year, it doesn't matter the reasons. COVID is, we're not going to be talking about COVID leave anymore. It's just going to be regular sick leave.
Okay, great. Ashley clarified she was talking about the COVID leave, but it sounds like the answer is yes, regardless.
Okay. Should I move on? We're almost out of time, and I do want to leave time for just general questions, although it's been great to have questions coming in throughout. I took a look, Lara, you had provided, I think, a fact sheet and some overviews to us of your members generally, what they might have. So it seems to me that there's some that will, let's call them generous policies, sort of 10 plus sick leave days already. Then you're not going to be impacted by this. You're already going to be meeting or exceeding it. If you're intermediate, like in your 5 to 10 days, well, it's going to depend on how many days are introduced. I have zero intel or insight to what that might look like. I have to think that going from 0 paid sick days to 10 without any form of employer support would be a huge jump. You know, you would think just politically, perhaps they would start small and then maybe incrementally move it. But your guess is as good as mine. And then policies that are perhaps meeting the number of days, but there's rules around how you can use it, or there's restrictions on when and how it can be used, what the rules are for qualifying, for example, passing a probationary period of a certain number of hours that's not just 90 days, or a waiting period, then that's not going to likely cover it. I should just clarify here, this I should have made it clear that's only for the COVID leaves. We don't think there's going to be reimbursement. When we first heard about this, the government in their announcements talked about reimbursement for the sick leave as well as the COVID leave. Well, we haven't heard that since, and it's not in any of the proposed statutory amendments or any of the further documentation. So I just don't think that it's going to be on the table. Okay, so I'm on to my conclusion here, and then I'll open the floor. We're going to have paid sick leave. I think that's one thing we know. It's a question of how many days is it going to be. I think now is the time to start looking at your existing policies, benefit packages, speaking with your benefit brokers, seeing if there's anything can be done to reduce waiting periods, shuffling benefits around, considering all of the different employee groups that you have, to decide, you know, if you think it's going to land on 3 or 5 or 10 days, how are you going to manage it? Because I can anticipate that given the lead time to this, it won't be long for unions to be bringing policy grievances if you do not meet or exceed, or if it's close. So you do want to, now is the time to be doing some preparations. And open to questions. I'm happy to answer anything.
Great, because they're rolling in. So Margot asks, this is just a clarification that after January 1st, employers may request a doctor's note again.
Correct. You can still request one now for non-COVID reasons. You just can't request one for COVID reasons. It's a bit of a silly distinction, but there you have it.
So if the employee, you know, doesn't have a doctor's note or doesn't have time to get one, would the employer be within their right to potentially decline the sick day?
Yes.
All right, thank you. Here's a question from Marina, and it's about the calculation for paid sick days. So it says, if the employee is part-time and is scheduled for a 3-hour shift but called in sick, would they get the average day pay or paid for the number of hours they were scheduled to work on that particular day?
I might have to take that offline. My gut says it should be the number of hours they were scheduled to work, but I'm trying to think, when I looked at that formula, it may be that it's the average day's pay. Can I take that offline and get back to you?
Yes, I think that would be helpful. That's a tricky one for sure. I'm also aware that
specific language.
Yeah, it does have to be specific. So I'm going to go back to a question that Chris was asking before, and she, like a lot of our employers, you know, have complex service delivery model. So she says, we have some casual employees in union care environments, and we also have casual employees in non-union homes. And, you know, if they're working in a union home, they won't be eligible, but if they're working in the non-union home, they'll be entitled because the operator has to implement a sick leave program consistent with the amendment. So her question is, in a non-union setting, can the employer implement the sick leave policy for part-time and full-time employees only and be considered compliant with the meet or exceeds clause?
No, because in non-union, you just don't have a meet or exceed analysis. So in a non-union environment, it's individual. You'll have to meet that statutory criteria. It's only the Employment Standards Act only talks about meets or exceeds in a collective agreement.
Okay, I think that's really helpful clarification. Hopefully that helps out, Chris. I have a question, and we'll answer this question and see if there's any other ones that come in. And this is more of a general question. Is, you know, obviously when you're bargaining collective agreements, there is you know, this tendency to look at the Employment Standards Act as a floor and use it as leverage. Now that we're potentially looking at a situation where, you know, maybe it's going to be 5, maybe it's going to be 10, you know, do we expect that bargain collective agreements are going to have to be richer with respect to sick leave?
Yeah, I do think we're going to have a bit of a push on creep here, because I think much like when minimum wage goes up, we hear that everyone has to keep that buffer between minimum wage and where they're currently at, so it all, you know, lose that gap. So I do anticipate that, Lara. It's a really good thought. I do anticipate unions coming to the table saying, well, you were this far above the floor and we want you to stay this far above the floor. So anticipating that, do some costing on what it, you know, if 3 days get added and you're going to be asked to add 3 days to yours to keep your gap or keep that far above the floor, definitely want to do some costing on what that looks like, or be prepared to push back to say, no, we're already meeting it, we're already exceeding it, so we don't need to touch that part of it.
Okay, well, the only other thing that I'm seeing come in here is somebody seconding the question about the formula. So I committed that I would work with you, Danny, to get an answer to that question and send it out afterwards. I want to be really respectful of everybody's time, but it's been so fantastic to see the engagement and all of the questions coming in. So I just want to thank everyone for attending the session, and to you, Danny, for taking the time out of your day to present on this topic and answer all of our really crunchy questions. Daniel, Danny, if individuals on the call here today have further questions about the new sick leave policy, what's the best way to get in contact with you or your colleagues at Roper Greyell?
Yeah, look, they can find us online. That's easy. Or Lara, I'm happy for you to share. I will send out a copy of this PowerPoint to you. You can share that, and I think I've got my email address and phone number. Yeah, I do at the end of that. So I'm happy to answer any questions, whether you're a client or not. We can just chat. That doesn't, that's fine. I'd love to hear from people what they're looking at, how they're dealing with this, and just have a discussion on that. No problem at all.
That's wonderful. Thank you so much for offering your time and your expertise. So on that note, I'll just say thank you to everyone for attending, and have a great rest of your afternoon.
Thanks, everyone. Have a good afternoon.
Bye-bye.